G'day. Yeah, g'day. This is about the constitutional Clarion, which is heaping up lie after lie after lie to prop up government rhetoric. And that's all it is. It's lies and fraud, an absolute disgusting display of how somebody is paid to be a professor and is reading from looks like a computer screen. But the big problem she has, this lovely person, she talks about local government and municipal authorities and councils, all in the same context. We have two systems of government, page 701 in this book that she calls it, shows you exactly how it's laid out, and it's on my Facebook page. And for your information and to me, I don't get anything from overseas. I am not disrupting a lawful government. We don't have one. You have told nothing but lies through the whole system of what you call local government, how it's lawfully established. You keep referring back to New South Wales. And in your next video, you refer to section 51, subsection 38, as empowering the federal parliament to do what they like to the constitution, basically. 5138, 5137. You refer to that. You refer to so many different things, and hopefully you will confuse people, but you didn't confuse anything. All you did is make out exactly what you are. Not a truthful person whatsoever. Because to sit there as a professor, you tell people to read the Constitution. Well, that's okay. First you talk about this one, which is the Constitution Act, as proclaimed and gazetted. That's for one. And you talk about this being a book written by Quick and Garron. No. Stop misleading people. This is the interpretation of the Constitution, which it contains. So, in fact, it is the Constitution, starting at page 260. Interesting, isn't it? Now, when you start reading from page 260, you read the 9 clauses and everything else. You said there was local government in New South Wales, but you didn't say it was anywhere else, because it wasn't. Then you talk about how it appeared in South Australia. Well, look at South Australia now. They've just passed laws saying they can take everybody's private land if it's not being used and do what they like with it. Rhonda Sibley, great to hear, but when is anyone doing something? Forget that. There's somebody doing something already. Go on to his page and you'll find out they're arranging something to do something, and we are doing something. I'm sick of people coming on here and making these statements, but when is anyone going to do anything? Well, when are you going to do it, Rhonda? That is the question. Now, let's go back to Ann Toomey. You talk about a 1974 referendum. That was to pay local government directly from the federal parliament. Did that literally add local government to our system? Yes, it did. If we had voted yes, but we did not. We voted no. 1988 referendum, you totally misread and misquoted that 100%. You did. Did we have local government then? No. It was without lawful excuse added to the state constitution. No lawful excuse. 1979 it was added. Western Australia with number 88 in 1979 to be exact. An act of the state parliament. You talk about plenary powers. That is a lie. Outright, straight lie. Why? Because you think you know everything and you can talk your way around anything. Well, you can talk yourself around whatever you like, but you have nothing in the Constitution to back up what you're saying. Nothing. You said the Parliament has plenary power. No, it doesn't say that. It says the Parliament has plenary power to pass acts that have been through the Parliament and passed according to the Constitution. Do they have to? Well, you referred to Sir Samuel Griffiths, didn't you? What about HCA 39 in 1915? Sir Samuel Griffiths, one of the people who put the Constitution together, was fully aware of the conditions of the Constitution. He stated at paragraph 148, here you find section 106 binds the state constitution and all laws made pursuant to it to the overriding authority of the Commonwealth Constitution. Read it and weep, it says that. Now, you refer to Glue versus the Granite Shire and Grummerhow, who refused to deal with one thing that was before him. One thing. Why? Because he's thick. What I said, I put 4 decisions of the High Court to the Western Australian Supreme Court of Appeal. Julie Wager, who sat in the District Court and is now supposedly the Chief Justice, but she's not. She's never sworn the lawful oath, so who cares what she says? She said the dicta of Isaacs had nothing to do with this case. The dicta of Isaacs was a 1923 case which he sat on, and he laid out the provisions of fee simple, how it alienates your land from the Crown and gives you total control. There is nothing in there that says the Crown still owns it, because it's alienated from the Crown. How's it alienated from the Crown? Under Chalice Real Property. That is an imperial act. I do not get any information from overseas except for what I glean off their universities and websites. Not opinions, constitutional fact. You come on here and you make out you're this, that and the other thing, and oh, look at that, the referendum in 1988. What took place in the 1988 referendum? Do you approve continuation of local government? We said no. Do you approve the establishment? We said no. Do you approve the empowering? No. Do you approve them being able to make bylaws? No. Why not? Because we didn't want them. We didn't want that. We didn't want them to have control over our land, which is what you're talking about. The purported services you're talking about, provision of roads, footpaths, parks, which is all they got the right to do. Don't worry about running town planning. That was a public service, had nothing to do with the institution named councils or roads boards or municipalities, which you decided you would call government. Where was the authority to give power to a registered company, which all your councils are? Look at your rate notice, ABN number, says they are trading companies. Oh, for GST's sake, that's a lie. I don't care if the Chief Justice of the High Court or any of the judges under him says it isn't. It's a lie, because the Act says it is. They're trading companies with ABN numbers. And you would know that if you bothered to read Anne Toomey like you tell us, or if you bothered to read this, you would find out your interpretation is nonsense, because the interpretation of the Constitution is found in the Red Book by the people who wrote it. Quick and Garron didn't write the contents. They wrote the book, or put it into its chapters as per the people who framed it, which you're trying to change the outlook. Was there local government before then? No, there were councils. There were municipal authorities. What does page 936 actually say? 8th line down. The states have the authority to set up municipal authorities. They already had them. And local government. They did not have them. Did not have them at Federation. And you say the state says the state set. Who puts legislation together at state level? The Parliament? No. The Executive, the Governor, and 18 people, 10 from the lower house, 8 from the upper, the Attorney General. And who holds the portfolios? They do. That's the executive government. There is no cabinet. There is no political parties. You say the Electoral Act is valid. No, it's not. There was an Electoral Act put in place by Queen Victoria in 1890 which said elections were taken state by state. Did the federal parliament have authority to change it? No, but who really cares? Because the federal parliament's never been lawfully constituted or set up. You can say it is, but the Constitution clearly says it isn't. Why? Because it doesn't meet the constitutional requirements. Have you actually had a look at that? I doubt it. You're too busy attacking people, trying to make out that you know everything. When I'm looking around, I've got all my paperwork here, I can look at it. But you refer to 2 books written by some bird brain about local government in New South Wales. New South Wales took the Commonwealth Parliament to court in 1923 and lost about being able to tax Commonwealth land belonging to the Commonwealth. The land belonging to the Commonwealth is the people. Was there ever granted authority over land to any parliament of this country? No, there wasn't. If there was, show me. Your plenary powers are not how you say them. I've explained before and you don't listen, but if you took the time to read decisions of the High Court, which you obviously have not, the High Court ruled in their sphere of legislative authority, the states have plenary authority to pass those enactments. High Court ruled it. Look it up, weep, and stop your nonsense. Now, let's get on to something else. Where does power come? From an authority granted by the people. Does it? Yes, go to page 701. It's got a diagram on there in Quick and Garran so that people will comprehend it a little clearer than the nonsense you're saying. The nonsense. We have a pretend Governor General. We have a pretend Prime Minister. How come you haven't addressed that when you see good old Albanese, after the Parliament has been prorogued previously, dissolved is what the word means. I showed you in 2 different dictionaries, but you don't understand that or don't want to understand that because you're too busy trying to attack people who have something to say about this book. I've read it for over 50 years. I've studied it for over 50 years. You say, oh, you studied in school in the legal... No, you were involved in putting that green piece of mucus together that you call the Constitution. Professors and all these Sir this and Sir that. It should be C-U-R this, cur this and cur that. Traitors to this country. Because you took the contents of this, which is the Commonwealth Constitution Act 1900 UK, this, the proclamation of the Constitution, and one by one, explanations by the people who wrote it. By the people who wrote it. Not you. You couldn't put any input. And what was your contribution to that? This book and the Green Book are exactly the same. No, they're not. No, they're not. Look at page 936 in the green one. It doesn't say anything like what you quoted, because you were quoting from this one. Oh, but this is only a book. Sitting on your shoulders this is only a head. This has got a brain in it. This has got eyes in it. Open your eyes and read and comprehend what I'm saying. You don't have any authority. You are there to teach people the true law, not what you think. Because, quite frankly, I don't think you do think. That's my opinion based on the nonsense that comes out of your videos. I've given you the benefit of the doubt and said maybe people taught you wrong, or you didn't really know what was going on, and such like, instead of calling you an outright liar. My opinion now is you are an outright liar, because you said you referred to this book in different pages, and you have. You referred to different things, and you have. And you recommend people do it, and you've written books. And those books don't make any sense. Lynn Courtney, who is she? She's a professor of law from New South Wales University. What she hasn't taken into account is a very serious issue which I filed in the court. But let's get back to what Grumman said. What was filed in that court was HCA 48 in 1996. It's when James McGuinty on the Labor Party, nasty little specimen, decided that the states existed before federation. And that's what you're trying to put over, your nonsense. And they could do whatever they like with plenary power and everything else. He put all that, and guess what? It was defeated in the High Court in 1996. Look it up. I've got it. I printed it out. I read it. It's fact. You're full of garbage. Again, another one of your dishonest statements or profound lies would be more to the point. You see, when you're going to lie about me, I'm going to tell the truth about you. When you look at page 936, look at the 8th line down. It says the states. That's powers of the states. That's not you. That's not the Parliament. The power granted to the Parliament by the authority of the people at an election, when those people individually, under the provisions of Section 8, represent the whole state in the Senate. Section 30, the whole state in the House of Representatives. Does it apply to the state constitutions? Yes. How? 107, 108 and 109 establishes the states. Or don't you recognise that? And if you do, you would comprehend this. HCA 48 of 1996 says exactly what I just said. 107, 108 and 109 create the states. Fine. High Court ruled it. In Jim McGuinty versus the state of Western Australia, they took on the government to try and change the law. Backfired. Two things. One, he was a little socialist dictator from the Labor Party. It didn't matter if he's Labor or Liberal. They're both crazy. Now, what effect did that have? The High Court ruled. 106, 107, 108 and 109 established the states. And they draw their authority referentially from the Commonwealth Constitution. Look at that. Draw their authority referentially from the Commonwealth Constitution. 106 states, at Federation, the states can retain their constitutions subject to this Constitution and altered in accordance with their constitutions. Clear? Yes? What does that mean to you, Anne Toomey? What does it actually mean? That means you can go and sprout off some more nonsense? You're not telling the truth, that's just it. So whoever taught you didn't teach you the truth, or, as I said, you're going back to making up your own little stories. Perhaps you got them from a foreign power. Now let's see, who would that be? Fabian Society, Freemasons, Druids, Buffalo, Zionists, and that's exactly where you're getting it from. And that is against our government. It is against the people who are the Commonwealth, who are the government. No, you cannot use Section 5138. It says with the conferral of the parliaments of all the states, like you said, not a bit. But then, Quick and Garron, who put it together, out of all the decisions of the Australasian, of the conventions, they put it together out of there, and the decisions of those conventions. We are not a democratic parliamentary democracy. That's a load of nonsense. We are a self-governing colony of England. We voted to retain that in 1999 referendum. We rejected COAG, which was literally the fourth attempt to put local government in, because COAG is Commonwealth Organisation of Local Governments. Am I telling the truth? Absolutely. So where's the seat of government, Anne Toomey? 125 says it's in New South Wales, 100 miles from Sydney, and it takes an area of no less than 50 miles square. And therein, second Anne Toomey clip, yeah, what a load of garbage. Anyway, this is what caused the trouble. January the 1st, 1901, Western Australia never put its lawful constitution in place. They put one in place with 32 sections missing. If you would like a copy, please come on here and ask me. I will send it to you, Anne Toomey, so that you can wake up. I can then send you the correct letters patent for the Constitution of Western Australia, put in place in 1989. Along with the Electoral Act of 1890, Western Australia. All are letters patent. Commonwealth Constitution Act 1900, this is the letters patent. It is an enabling act. It enables us to have a constitution. Have you read that? In the front page, mate. It enables the Commonwealth, which are the people. You see, when the colonies became states, the Boundaries Act no longer applied. When the Commonwealth was established, it was established as a self-governing colony of England, and that act then applied. So you're talking about waters between the shore and the 12 nautical miles. That's in states' control? No, it's not. The states cannot have a boundary. There are no borders to set up all your little areas where you want to put and play games with jabby jabs on people. You know? Quarantines says you can't do it. Section 69 removes it from the states, put it in a federal parliament under 51 subsection 9 and 10, I think. But it's all there. It's all there. So you say the states can set up local government. This is you. Show me in section 51 where anybody has authority over land. Federal Parliament can take it on just terms for public use. Is that a fact? Yes. And what do you know about it? Nothing. Nothing. When the Constitution was established, under the 9 clauses, we inherited a lot of imperial law. One of them was Chalice Real Property, 3rd edition, as in the 1904 case, the 1923 case, and the 1998 case being Fijo versus the Northern Territory, where native title does not extinguish fee simple. Doesn't. Can you have a royal style and title in relation to the Crown of England? No. Why? We're a self-governing colony. We, under the Colonial Laws Validity Act and the Constitution, it says, even if this act had never been enacted, it is beyond the legislative authority of any colony of England to change any imperial law. And yet you've stated numerously that Magna Carta is a statute. They can change it. Magna Carta, it is not a statute. It's a Charter of Rights. So was the 1688 Bill of Rights. So was habeas corpus. So was the Act of Settlement. I seem to remember Queen Elizabeth going before the British Parliament and said, leave the Act of Settlement alone or I will sack the Parliament. She said that. Check up. I did. I read it. You seem to think, yeah, she needs to be stopped and held accountable for perpetuating the fraud and debt base. Yeah, that's exactly what she's doing. Don't worry about it. She's going to get it. Now, it is time for you and Toomey to come out and tell the truth. You see, I have a book here. It's where the Aboriginals were given the same rights as us. You didn't know that? Same rights. How come they didn't get them? I can show you why, because it's in here. 51. Yep. Because we said they were going to have the same rights as us to vote. And look what you got. Section 51, subsection 26. The people of any race other than the Aboriginal race in any state for whom it is deemed necessary to make special laws. So what did you do? You lied and you took out other than the Aboriginal race in any state, and then the people of any race for whom it is deemed necessary to make special laws. So you gave yourself authority to make special laws. You also took out 127. How do we know that? Because it says so. You took it out of here using the same referendum. So what did you do? Lie. And there's the referendum that might interest you. It's 23A. The provision of maternity allowances, widows' pensions, child endowment, unemployment, pharmaceutical, sickness and hospital benefits, medical and dental service, but not so as to authorise any form of civil conscription, benefits to students and family allowances. That's what was there, and that was the result of a referendum. How come they haven't done all that for free? They charge you to go to school. Don't say they don't, they do. All schools have to pay a minor fee. Well, they try to get it out of you. But people won't listen when you tell them you don't have to pay. The 1942 Great Tax Case, read it, and then come back and tell us we got to pay. The states have to pay tax. The people of the state has to pay tax. Or the states can collect it. You see, there were 4 cases before Wheeler, Pullen and Buss on the 6th of November 2006 when I put my case to the Supreme Court. There were 4 decisions of the High Court which they ignored. That is criminal contempt of the High Court. When it went to the High Court, Grumau, your little friend that you quoted from, refused to grant leave to appeal, special leave to appeal. Now, in the Constitution it says we need leave to appeal. It doesn't say anything about special. And Grumau, being a single judge, sat in the Star Chamber hearing, Synagogue of Satan, according to the Act of Habeas Corpus, which was abolished in 1640. Was it? Yes, read it. It says so. Is it current? Yes. HCA 44 of 2010. Full bench of the High Court, 1688 Bill of Rights, habeas corpus, and all imperial law is law in this country and must be abided by. That's Chief Justice French. You're going to call him a liar? I think he knows a little bit more about the law than you do, Ann Toomey. Quite a bit more. You got a professor, you profess. So you talk, professor is a person who talks about a particular subject with authority, purportedly. But you may have the authority, but you don't have the knowledge. You say you do, you say we're just keyboard warriors, we're this, we're that, we're the other. No, we're not. We're people who are sitting in this country waking up to the nonsense that pours out of the mouths of people like you who put forward government policy, not fact. You see, you're pushing the 1973 garbage from Whitlam. There was no lawful federal parliament. So let's go back to your lovely state of New South Wales, which you like to sprout about. They did this, they did that. They didn't exist after August 1902. That's when they removed their state constitution and replaced it with another one in direct contravention of 106. Did they do it? Yes, and they said so recently when they decided they're not going to have magistrates anymore. They're going to make them all judges, under the authority, according to them, granted by the 1902 Constitution of New South Wales, which never ever existed. 106 says the state constitutions can continue. On the 29th of October 1900, Queen Victoria made every state constitution in its original text a letters patent. The Office of Governor, letters patent. Commonwealth Constitution Act, letters patent. Instructions to the Governor, letters patent. Electoral Act for each state, letters patent. Then you explain to me how a parliament that serves the people goes against the Constitution and overturns imperial acts, even though we voted to retain the crown in 1999. We did. We voted to keep it. We didn't want coag. So why do they, all the nice little people, politicians, premiers and that, go to Cairns to collect some money? They borrow it from what? From what? And who borrows it? The political parties. Who are they? Registered companies, businesses. You see, you can sprout off and say local government is legislative authority of the state parliaments. But this is a little clanger for you that you should wake up to, because what I did is I put all this to the Magistrates Court in Geraldton in 2019. The magistrate ruled he had no power to order me to remove my property off my land. Then he said, I have no authority. No, he didn't say no authority. He said, I cannot give you ownership of his land. I do not have the authority because of what I said. And I won. But the Nice Council had sold my property 4 months before, or a little more before that. They sold it for about an eighth of what it was worth because they wanted to get rid of it. Aren't they nice? Because they took the money they got, took out 148,000 they reckon I owed, but I actually proved in the court I didn't owe a cent on 2 occasions. So you lied about nobody ever defeating the Local Government Act in court. I did. I proved it was fraud. I proved the magistrate by swearing, I, Chris Miosevich, do solemnly swear I'll serve the people in the state of Western Australia. The people are the state. They're the ones who were gifted the authority to set up municipal authorities and local government, being the state parliament, which is a subservient parliament to the federal parliament, which in turn is a subservient parliament to the British Parliament. Where do you find that? In here. In the annotated constitution, which is the interpretation by the people who framed it. Not the green one, the unauthorised one that you somehow went in your space cadet time machine back a few hundred years, or a few dozen years, to meet Dr. John Quick and Sir Robert Garran, who had passed away by both of them by 1957. But let's go back to your state constitution that you're so in love with and the powers of the states. Western Australia never put its constitution in place. They put a fraudulent one with 32 sections missing. So Western Australia was set up under 107, 108 and 109, but it could not comply with 106 because it put a fraudulent constitution in place. You say all these other laws are just transferred over after Federation. No, they did not. No, they didn't. The Constitution Alteration Act of 1899 was put there by a fraudulent state parliament who embarked on a big argument with all the miners from around Kalgoorlie and Southern Cross and all those places who were trying to hold up Federation until they gave in and paid them the correct amount of money for the gold they were mining. That's a fact. It's on the wall of the Boulder Hall in Kalgoorlie. Kalgoorlie, Boulder, they're a joint city. Go and have a look, it's on the wall. Big problem you have, in August 1902, New South Wales removed its constitution and replaced it. There's 2 states out. 1934, South Australia, Tasmania did the same. 1922, Queensland removed its upper house. By 1975, the Victorian Constitution was so dilapidated it was just a piece of unwritten garbage from the politicians, and they decided they were going to do this, that and the other. And they replaced it with another one, which was just as debauchery as the early ones. So where did you get the current federal parliament? You didn't have one. So after 1986, when you claim the federal parliament had this authority for the Australia Act, it didn't have any. There was no federal parliament. From January the 1st, 1901, when Western Australia never put its lawful constitution in place, right up until now, there has never been a lawful federal parliament. You can tell me I'm wrong, you can lie, cheat and steal, but this book, the Blue Book, by political parties, and this act says that you're the liar. You're the people spinning nonsense. You're the person using political parties and foreign agreements and fraudulent decisions that you think are binding on us when they're not. To overturn the correct system of government and change it to one that suits the political parties, you answer me. You think I'm wrong? I'm calling you out as a rotten liar. You think that's slander? You take me to court. I'd love to see you in court because that's where you belong. But believe me, when you take me to court, I've got a surprise for you. And you, I'm a Commonwealth public official, not appointed in this country, appointed from England. I have authority, I have the right, and I have the duty to report indictable offences. You want to take me on in court, I will bring out the offence of treason and fraud committed by you, and I have the evidence from all of your lovely little constitutional Clarion videos. You want to threaten people, you want to make fun of people, you better jack up your ears and engage your brain. It's not working properly. What you're saying is nonsense. I only say what I can prove. I have the documents to prove everything I've said today. You have nothing except your idea and your mucus green constitution. You think you can file in the court and bring it there? Go for it. The big problem you've got is there are no lawful state courts. None. Absolutely none. But there's no lawful High Court. Last year, we filed a quo warranto on the High Court, the Chief Justice and all the justices, to show authority, which the Constitution states clearly you have to have. You'll find that on Chapter 3, Section 76, page 795, the 4th paragraph in this. If you exercise authority throughout the Commonwealth, you have to show where in the Constitution does that authority come from. Can you show where the political parties have authority? No. Can you show where the states could remove their constitutions? No. 106 says they can't. They'll let us patent. Can you show where all this authority you claim they have comes from? No. Can you show that we didn't say no to the continuance of local government? No to the establishment. Can you show where right up until 1954 you couldn't tax land? It's there. You couldn't tax land. The 1904, the 1923 and the 1998 case proved you had no authority over land whatsoever. None. Not one little bit. Nothing. It was sold to you from the Crown through the Crown's representative being the Governor, who gave you a lawful title, your title, to your land. Could you keep records of it? I don't think anybody would worry about that, for the public service to know who actually owns the titles, but can you hold them? No. So Landgate is sitting there, a registered company, holding our titles which they stole. Yeah, no they didn't, Darren. That's what they're claiming, but it didn't happen because they can't. It's fraud. Fraud vitiates everything when it's established, so don't worry about that. They did do what you said, but they didn't have any effect on any of us. You see, page 286, Mr. O'Connor, one of the people who contributed to this and wrote a section in this, he said if it was asked of a politician whether he's the highest authority in law in this country, he would say the state constitutions. That leads near the truth but doesn't reach it, because the supreme, absolute and uncontrollable authority belongs to us, the people. Us, the people. And it means Aboriginal natives, white natives. Well, that's what we are. We're natives. We were born here. Are you sticking up for us, Ann Toomey? No, you're not. You're peddling political party nonsense and calling it fact, and it's not. Anthony Raby, proof of claim. I've got everything here sitting in front of me and just over there that proves everything I've just said. And Toomey, you have absolutely nothing except books that you've written which are not correct. If you don't like what I'm saying, as I said, take me to court. And as for pensions, since January the 1st, 1946, every worker has been taxed 7.5% of their wages to pay for their pension. We're not getting it. Is it means tested? No. Can you do it? No, because that is blatant discrimination. Are politicians means tested? No. When a politician leaves his job, does he get the full pension? Yes. How come he only gets half? Because his wife can still go to work. Why isn't she made to go to work? You want mine to go to work? Otherwise you pay me not even full half of the pension. But you're supposed to pay me the basic wage every week. I paid for it. Did I? Yes, absolutely did. Are you paying it? No. There's so many ways that the Parliament, so-called government, which they're not, they're only a Parliament, who have absolutely no authority except what was granted by the Constitution. You can sit there and you can keep lying, and as I said before, you keep lying about me and lying about the people. I'll tell the truth about you. If you don't like it, you can turn around and you can take me to court and try and prove what I said is incorrect, but you won't, because you can't. You won't, because you can't. The letter I put on my Facebook page, if you read it, it lays out majority of what I said, and I've got the documents to back it up. I don't make statements I can't back up with actual factual documents, and I have. And I'm sick of people like you putting out your constitutional Clarion, or David the red-headed warrior, who says the political parties have full control of the military. If they have, he's admitting to blatant treason, both by him and knowing it and not doing it, and by the political parties having control, when Section 68 of the Constitution says the Governor-General has. That's providing we had one, but we haven't got one. It's not lawful. All the clowns they swore into the federal parliament never swore the lawful oath in the Constitution. Section 42 says every senator and every member of the House of Representatives, before taking their seat, must swear the oath in the Constitution. None of them did. So the Governor-General committed however many numbers act of treason. And if someone swore on the Quran or anything else, I got nothing against Islam. That's their religion. They can have it, but they can't swear on the Quran. They don't have to swear on the Bible, but they have to take the oath of affirmation if they don't swear on the Bible. That's fine. But until they do, they can't sit in our parliament lawfully, and they're not. So there you have it in a nutshell. You want to have another go around to me? And your idea of the provisions of section 51, 37 and 38 are nothing but a load of political claptrap. Absolute lies and nonsense. Any alteration to a letter's patent, one letter, is criminal. So where do you get what you said about 51, 37 and 51, 38? It's all lies. You want to prove I'm wrong? Let's go to court and debate it. But you haven't got any courts. You better have somebody if you want to take me to court, because I have a lawful right to challenge the jurisdiction of your so-called courts, and none of them have any. That's what I did when they withdrew the charges against me, or charge against me, which didn't exist anyway. They could never prove jurisdiction. They still cannot. If you want to prove local government has authority, you explain this. That idiot Van Stein stood outside the city of Geraldton and said, all your rates pay for all these services for the road. Hang on. Don't we pay massive amounts of money in the trillions for fuel tax every year? Isn't that for the roads? Isn't there a percentage goes to the states to pay for the roads? So then we pay for the council to pay for the roads. Then we pay car licence to pay for the roads. Driver's licence to pay for the roads. We'd have the best gold-plated roads in the world instead of the biggest load of garbage with potholes. What the hell is wrong with you? Can't you see that people can see through your lies? And the rubbish. Every council is granted a certain amount of money to take the rubbish away. The council pays, last I looked, 30 cents per bin per week. Add it by 52, doesn't add up to the amount of money they're getting. Is it theirs? No. They're getting taxpayers' money. How come there's still billions of dollars every year given away? 52 or 54 or 46 billion, whatever it is, they give to the Aboriginal natives. And where does that go? Have you ever tried to take account of that? No. Who told you could give all this money to overseas country when the Constitution clearly says all money in excess of the federal government's debts must be returned to the states in relation to head of population? Read it. It states that. Or you're going to deny that's in there. I'll read it to you if you want, Ann Toomey. The big problem is, Ann Toomey, you want to attack me, give it your best shot. I'll attack you back. Wake up. Wake up. You're going to pay. Every single clown who sits in our parliament, our universities, our schools, our courts, in the police forces, every lawyer who goes before the court and lies on fraudulent laws enacted by a fraudulent parliament, you're going to pay. And our payment is we take every single thing you got. You know, I went to a funeral the other day of an old gentleman who bought his property. He was swindled out of it by a law firm and a bunch of vultures that thought, even though their father had sold the property to these old guys, he lied and said he could subdivide the property when he couldn't, and therefore joined them all to one title without their permission. All the evidence was there, and the judge got on board and lied as well, and they took every single thing, and one of them died the other day with nothing. I sat there and I looked at the peanuts sitting in the council and went past the law firm. Mate, the things you could do with a decent-sized waddy, give them a flogging. I am sick of you idiots. You're going to pay. And believe me, the clown, I don't care if you look at me, I'm coming after you. I'm going to bring you down and you're going to jail. You're a fraudulent, lying thief. They worked all their lives on properties, driving bulldozers, planting crops and taking them off, and you took everything. Just like you idiots from the United Nations think you're going to take everything. No, you're not. You are not. You would like to, but you're not. So, dwell on what I said. Sort of long, but definitely truth, every bit.